Hello viewers, I am Dr. Shivani Gupta from University Institute of Legal Studies, Punjab University, Chandigarh. It is my pleasure to welcome you to this session on an intriguing topic in the law of property, transfer of property to an unborn person, judicial interpretations. This topic lies at the intersection of property law and jurisprudence, raising fascinating questions about transfer of immovable property to an unborn person, the rules governing such transfers, the time span when the property may actually vest in the unborn, and the safeguards embedded in our legal system. We will delve into the nuances of the law, examine landmark judicial pronouncements, and analyze how courts have interpreted and applied these principles in various cases. Transfer of immovable property is dealt under the Transfer of Property Act 1882 in India. In general, this act under section 5 elaborates upon the concepts that study transfers inter vivos, that is to say, transfers between living persons, in contrast to testamentary transfers which take place according to wills. Section 5 of the Act reads as, where on a transfer of property an interest therein is created for the benefit of a person not in existence at the date of the transfer, subject to a prior interest created by the same transfer, the interest created for the benefit of such person shall not take effect unless it extends to the whole of the remaining interest of the transferor in the property. Thus, for a transfer to take place under this act, it is essential that both the transferor and transferee must be living at that time. It thus implies that a living person cannot transfer a property to a person who is not alive, including a person who has not yet taken birth. In these circumstances, let us try to analyze a situation. Mr. Seth, 80 years old, owns a very huge and luxurious mansion, probably worth 50 crores. His only son is a drug addict in whom he does not want to transfer the property, but wishes the same to be transferred to his grandchild from his son's future marriage. Now, the question arises, can he transfer this property to his such future grandchild? The answer to this question lies in section 13 of Transfer of Property Act. Under section 13 of Transfer of Property Act, transfer of property in an unborn child is permitted. To study the underlying concept, an unborn child shall mean A point, a child who is conceived and is in the mother's womb such that he may or may not be born alive, and B point, a child who has yet not even been conceived. It is, however, important to note that section 13 clearly states that it is not a transfer to an unborn child, but only the transfer for the benefit of an unborn child. However, such transfers are possible only upon the fulfillment of the following conditions. First is, a transfer even for the advantage of an unborn person cannot be made directly. Even such transfers have to be preceded by a prior or existing life interest. Life interest may be understood as a right of enjoyment or possession of property. This is to prevent a situation in which the property may be left without an owner from the time of its transfer to time of the birth of the unborn person. It is important to note that such life interest must be devolved in a person living at the time of such transfer, so that he may hold the property during his lifetime, which is to be ultimately passed on to the unborn person who by that time would have already come into life. Thus, in our situation, if Mr. Seth transfers a life interest in favor of his son for life and thereafter absolutely the remaining interest in the unborn child of his son, then such a transfer of his mansion in favor of his unborn grandchild is valid. It is important to note here that the transfer of interest in favor of Mr. Seth's son is for his lifetime, and it is only after his son's death that the interest in the mansion would pass on to his unborn grandchild, who is the ultimate beneficiary in this whole transfer. The transfer of interest in favor of Mr. Seth's son can either be for his whole life or for a stipulated duration like 30 years, 50 years, etc. Though only a limited interest can be transferred in favor of the son, however, it is again a statutory requisite that only an absolute interest in the property may be transferred in favor of an unborn person, as was held in F. M. Devam Ganapati Bhatt versus Prabhakar Ganapati Bhatt of the year 2004. Meaning thereby, Mr. Seth's son has a limited interest such that he does not have the power to alienate. However, once the property is transferred in favor of his grandchild, it would be an absolute transfer, he even having the rights of alienation. This is also very well portrayed under the illustration appended to section 13 of the Transfer of Property Act. The illustration reads as: a transfers property of which he is the owner to B in trust for A and his intended wife successfully for their lives, and after the death of the survivor for the eldest son of the intended marriage for life, and after his death for A's second son. The interest so created for the benefit of the eldest son does not take effect, because it does not extend to the whole of A's remaining interest in the property. Similarly, had Mr. Seth transferred a life interest in favor of his son, then another life interest in favor of his unborn grandchild, and then ultimately absolute transfer of interest in favor of his unborn great grandchild, then such a transfer both in favor of his grandchild and great grandchild would have been invalid. It is also important to understand here that if the unborn child, that is Mr. Seth's grandchild, for whose benefit the whole transfer was made, does not take birth alive till the lifetime of the last person in whose favor the life interest was created, then the property under question shall devolve upon the heirs of Mr. Seth as if he died intestate. Thus, the conditions precedent for the application of section 13 may be summarized as under. First is, no property can be directly transferred to an unborn child. Second is, any transfer for an unborn child must be preceded by a life interest in favor of a living person at the time of transfer. Third is, nothing short of an absolute interest may be transferred in favor of an unborn person. Fourth is, the unborn child must have come into existence during the lifetime of any one of the persons in whose favor the life interest was created. This principle finds its base in the English law doctrine of double possibilities as accepted in the Whiteby versus Michal case, wherein the first possibility is the unborn taking birth alive and the second possibility is the offspring of the unborn taking birth. The most prominent Indian case law on this point is Girjesh Dutt versus Data Deen. In this case, A gifted her property to B, the daughter of her nephew, for life, and then to B's male descendants if she had any. If in case B had no male but a female child, her property would be given to B's daughter without the ability to alienate it. Further, if B had neither male nor female descendants, then the property was to be given to her nephew. B passed away without any child. It was held that the gift in favor of B for her lifetime was valid because she was alive at the time of transfer. However, the gift in favor of B's daughter, who was unborn at that time, was void within the statutory stipulations under section 13, because absolute interest was not transferred in her favor. The court further ruled that any subsequent transfer that depended upon this transfer had also failed. However, in the case of Raja Bajrang Bahadur Singh versus Thakurdin Barkate Kaur, the Honorable Apex Court held that where a gift is made to a class or series of persons where some are existing at the time of transfer while the others are not, such a transfer does not fail automatically. The transfer stands valid for the former category while stands void for the latter category. It can thus be argued that section 13 does not create any limit on the number of life interests that may be created in persons living at that time. Therefore, if Mr. Seth creates a life interest in his brother, then after his death in his son, and then transfers an absolute interest in his unborn grandchild, even then the transfer is valid. It was also settled in Javadi Venkat Satyanarayan versus Faiboya Manikyan and others that even if the life interest has been relinquished in favor of the transferor by the person benefited even before the birth of the absolute transferee, such a relinquishment shall not invalidate the transfer in favor of the unborn child upon him being born alive. Even a child who has not yet taken birth, but is conceived and is in the mother's womb, is considered to be a child in existence for the purposes of this provision, both under Hindu and English law, as was held in the cases of Ilya versus Joyce 1935 and Long versus Blackall. This is guided by the principle of N. Venter Samir. Property can, however, not be transferred to an unborn child under Islamic law. The question that arises is, when do the rights in the property become vested in the unborn child? So, now we will study about the vesting of interest in the unborn. Section 20 of the Transfer of Property Act specifically contains that when a property is validly transferred for the benefit of an unborn person, such an unborn person develops a stake in it upon him being born alive, though he may not be able to enjoy the possession immediately on birth, but a vested interest in him is created. Section 20 thus complements Section 13, clarifying that the property can be transferred for the benefit of an unborn person, provided there is a clear and valid transfer mechanism. Next is vesting of interest and the rule against perpetuity. The vesting of this absolute interest is guided by the rule against perpetuity as contained under Section 14 of the Transfer of Property Act and also established in Duke of Norfolk's case. The rule against perpetuity or remoteness of vesting refers to the time frame within which an interest in property must vest according to law. If the vesting is considered too remote, it may be invalidated. Since the term perpetuity means an indefinite period, wherefore, the rule against perpetuity stipulates that the vesting of the interest created in an unborn cannot be postponed beyond the lifetime of the person or persons in whose favor a life interest is created, in addition to the minority of the unborn. Thus, it prohibits the transfer of property from one generation to another and thus restrains it from becoming inalienable. The combined effect of Section 14 and 20 stipulates that the postponement of the vesting of interest in the unborn child can be done only for the minority of the unborn. Section 14 even recognizes a child being conceived as a child in existence for the purpose of the combined application of Sections 13, 14 and 20. The postponement of the vesting of interest in the unborn child depends upon the period of life plus the duration of the minority of the unborn plus the period of gestation, maximum 280 days, if the unborn was conceived before the death of the last life interest holder. Let us study what is the maximum remoteness of vesting. For this, let us analyze the following situations to study what would be the time for which the vesting of interest in the unborn may be postponed. Situation 1. Mr. Seth created a life interest in his brother and then in his son. It is important to note here that such life interests are run consecutively. No grandchild was born till the lifetime of Mr. Seth's son. On Mr. Seth's son's death, the property shall devolve upon the heirs of Mr. Seth as if he had died intestate. Situation 2. Mr. Seth created a life interest in his brother for life and then in his son for life. During his son's lifetime, Mr. Seth's grandchild was born and was already 20 years old at the time of the death of Mr. Seth's son. The absolute interest in the grandchild shall devolve upon him immediately upon the death of Mr. Seth's son. Situation 3. Mr. Seth created a life interest in his son. The maximum period for which the vesting of interest in his grandchild can be postponed is for the life of Mr. Seth's son plus 15 years 9 months. This is the time we get from 18 years minus 2 years and 3 months. Situation 4. Mr. Seth created a life interest in his son. His grandchild was not born by the time his son died, but was already in his mother's womb for 140 days. In this case, the maximum period for which the vesting of interest in his grandchild can be postponed is for the life of Mr. Seth's son plus 140 days. This is the time we get when we subtract 140 days from 280 days plus 18 years. Following are, however, the exceptions under section 14 of the Transfer of Property Act, wherein the rule against perpetuity does not apply. First is where the property is made for the benefit of public or for the purpose of advancement of religion, knowledge, commerce, health, safety or any other object beneficial to mankind. Second is where the income of the property is accumulated for the payment of debts of the transferor. Third is in cases where no new or future interest is to be exercised in the property after the mentioned time period. Next is contracts made for continuous renewal of leases. Next is personal agreements or obligations, such as an agreement to appoint a family of pujaris from one generation to another and making provisions for the payment and expenditures is valid. Next is creation of a charge in a land does not amount to a transfer, thus is not affected by this rule. Similarly, any covenant which is annexed to the land, since it passes with the land itself, it is not tainted with the application of this rule. Next, we will talk about transfer to class of persons. Section 15 stipulates a situation where interest may be created for the benefit of a class of persons. Class of persons refers to the persons who shall fall within a certain describable or definable category designated by a general name like sons, grandsons, nephews, etc., such that whenever they take a unit to be proportionately shared depending upon them being born alive. A class of persons refers to a group of individuals who share a common characteristic and are collectively referred to in the creation of an interest in property. It herein states that if such an interest fails with regard to some of them due to the application of the provisions under section 13 or the rule against perpetuity, such failure shall be in regard to those persons only and shall not affect the interests of the whole class. For instance, if Mr. Seth, after creating a life interest in his son, creates an interest in his unborn grandsons, such that the property is to vest in the eldest grandson for a life interest, absolute interest upon the second eldest upon him attaining the age of 25 years, while is to vest in all his other grandsons at the attainment of majority. Herein, the transfer in favor of his eldest grandson is void under section 13. The transfer to the second eldest is void under section 14, while they shall be operable against the other grandsons. Next, we will talk about a situation where failure of an interest created upon another interest fails. Section 16 stipulates that where a valid transfer is subsequent or dependent upon another void transfer, the transfer is itself rendered void. Similar was the case in the landmark decision of Girjesh Dutt versus Datadeen. Let us understand it with an illustration. Mr. Seth transfers a plot of agricultural land to his son for life, and then to such of his unborn grandsons who shall first attain the age of 19 years for life, and after the death of such grandson to A. The transfer to A is intended to take effect after the expiry of the life estate of Mr. Seth's son's son, which is void under both sections 13 and 14. A's interest shall fail under this section because it is intended to take effect on the failure of the interest of Mr. Seth's son's son. On the other hand, subsequent interest would not fail if the prior interest is legitimate, but fails later, for instance, that the condition that the transfer was relying on was not met. Thus, to conclude this very topic, the basic idea here is that no one who transfers property to another may create barriers that prevent that property from being freely passed down to one or more generations. Thus, the absence of such a regulation will deprive society of many advantages that may ultimately prove beneficial to the public. In the absence of free movement of property, a civilization can easily be destroyed. This regulation is therefore necessary for benefiting the society and future generations, as well as for the easy enforcement of the law and the free and active circulation of land. This rule ensures that property interests do not remain uncertain or unvested for excessively long periods, promoting the free transferability and economic utility of property. That's all for today's lecture. Thank you. Goodbye.